Hello everyone, thank you very much for joining us today. My name's Kaylee Swift and I'm the Director here at NB Property Law. I'm going to be taking you through today the Commercial Lease Exit Guide and what you need to know as a tenant or landlord before actually having the lease end. So my role here at NB Property Law is we're part of the No Borders Law Group. I focus on the property, commercial and estate planning pillars of the business. So I'm one of the directors here, and basically my role is to, essentially deal with all these property, commercial, estate planning matters with which we have come across our desk from day to day. I work with both individuals, families, and also business owners to help them navigate the complex property transactions, their commercial contracts, and also dealing with their long-term asset protection strategies with confidence. So my extensive experience is in estate planning, commercial law, and property law. I'm advising clients on a day-to-day basis on their estate planning documents, including testamentary trusts, looking at their asset structuring and succession planning. I'm also making sure that my clients have their wealth and business interests actually protected so that they can have peace of mind both now and into the future to know that's taken care of. I've combined my commercial and property law background to enable me to actually be able to deliver integrated strategic advice to support my clients' businesses' growth and their risk management and also their long-term wealth preservation. So I'm passionate about commercial, estate planning and property law, and I'm always striving to provide that holistic, practical legal advice to align with my clients' broader financial and also their business objectives. But essentially, above all, my priorities are essentially delivering advice in both a clear way for clients so they actually understand what I'm talking about in terms of the commercial terms that they're going through, and also ensuring that their property transactions are done seamlessly so that the outcome is that they've essentially got genuine support to ensure that their business, individual and family goals and successes are able to be achieved. So in terms of today's webinar, we're going to go through obviously the lease exit guide and focusing predominantly on the actual make good clauses that we see in those commercial leases. So a lease can end for a range of different reasons. We've got some of the key issues listed up here as to why a lease may end. Obviously, the most common is that the fixed term has essentially come to an end. So when you're entering into a lease, we've got a fixed term on that generally, and that might be for a number of years. Often there can be an option period as well that could be enacted. So it could be a 5-year lease with an option period of 2 further 5-year terms. Once that final period has expired, the lease could, while it could go into a holding over period for month by month, essentially expired. And at that point in time, that's, when the lease is considered ended. Another way that a lease can come to an end if the parties actually mutually agree to terminate the lease. So often leases are for a long period of time and situations change. Landlords and tenants can have varied situations and circumstances that arise during that term that may need them to actually terminate that lease early. Now, it does not matter that situation arises. They're still locked into this lease for that period of time. However, there's nothing stopping both parties mutually agreeing to terminate that lease at an earlier period of time. And if that was to be the case, we would assist in doing what's called a surrender of lease, or potentially if they've found someone else to take over that lease, it could be by way of an assignment. If it was assignment, though, that would likely then mean that the incoming tenant would then be responsible for those make good works. The third example we've got here is that if the landlord was redeveloping the premises, so often leases will include a clause for redevelopment, not always. From a tenant, obviously, their risk with having that in a lease. From a landlord's perspective, it does give them the flexibility that they need, potentially if they purchase those commercial premises with the idea that they would redevelop that property within a period of time, which coincides with the lease term. So essentially that lease would then come to an end at the date that the redevelopment notice was given. That generally allows the tenant a period of time, and then it will come to an end once that notice expires. Another way the lease can come to an end is if there are unremedied breaches and the landlord has exercised their right to terminate the lease. So a landlord in Queensland, there's certain ways that we go about, notifying of the breaches that have occurred, and if that's been the case and that the tenant still failed to actually comply with their lease obligations, then the lease could be considered terminated at that point in time. And again, it's come to an end. Now, the last example we've got listed up here is if the premises actually become damaged and irreparable. So, often, given the state we live in, we have different things, fires, floods, things like that could rip through the premises. That means that it's essentially, it's not in the landlord's best interest to try and, spend this amount of money. Potentially, maybe insurance is not going to cover it, whatever it may be. And it's basically then seen as damaged and unrepairable. And there may be a lease clause that allows for the lease to terminate in those situations. I haven't listed up there, but another example as well could be often I've spoken about redevelopment, but sometimes there's demolition clauses quite often included in leases. Now that allows landlords to basically demolish the property. Again, it could be leading into because it's damaged beyond repair. I suppose a recent example of that one and quite a well-known one was back in the 2022 floods. Probably a lot of people may remember the 45-year-old shopping centre, the Toombul shopping centre at that point in time. Essentially all those businesses had their leases terminated by way of a demolition clause that was included in there as a result of basically the centre owner, which I understand was Mirvac, triggering that demolition clause in all of the leases to terminate them due to the essentially impracticality of the repairs and the high likelihood of future flooding actually occurring in that precinct. So a few different ways that a lease may come to an end, and then we need to essentially move on to when the lease ends, often what is going to catch the tenants and landlords off guard and how they actually stay ahead of those obligations. So the end of the lease term is a high risk for financial impact. Sometimes tenants haven't taken into consideration that, why they might have spent, $700,000, $1 million on this, extensive fit out that they've done at the outset of the lease, and maybe the lease has gone on for 15 years or something like that. Once that comes to an end, often with a make good clause, they've got to then go back and bring that premises back to essentially a bare shell what they started with, which can sometimes cost significant amount of financial money to do that. We also need to be aware of what are the condition obligations as well attached to that make good. What does it actually stay and how do we go about doing it? We spoke about before, like the early termination and the break lease clauses that could be in the lease. I mentioned briefly holding over. So often leases, as I mentioned, they're going to have a fixed term. And what happens when that fixed term comes to an end? It doesn't just mean that landlord says, oh, we haven't got a new lease because we're still negotiating, we've got to kick you out until, we look to get one in place. The holding over clause allows for the tenant and landlord protection to allow the lease to continue on, generally on a month-by-month basis, on essentially the same terms as what the initial lease was. The last thing is, final adjustment of outgoings. So often in our leases, they've got, if there's outgoings that are payable, so it's not like a gross amount that we're paying inclusive of outgoings, and outgoings is something in addition to the rental amount. Outgoings are generally what will happen is a landlord or their managing agent will issue them with an estimate notice at the start of the financial year saying this is what we estimate the outgoings to be. So you'll pay generally that amount monthly on a monthly basis as an equal amount in addition to rent. Then what happens is come the end of financial year, obviously that was just an estimate. Some things, fluctuate. You might be up for, often it's generally more. Sometimes it could be less in certain situations where, things have happened or risen, and they'll then basically reissue another statement saying, this is what the actual amount of outgoings is. And generally that's an audited statement. So, come the end of the lease term, there may be a final payment to allow for that adjustment of outgoings as well. The last one as well to think about, once we've done everything in terms of make good and landlords all happy with that, is making sure we actually get the return of the bank guarantee and potentially any security deposit that we put down as well. So, that's important because essentially while the bank guarantee is only a piece of paper, to the bank, obviously it is worth something, and we want to get that return to the bank to essentially free up that cash flow or whatever has been tied up as collateral for that bank guarantee. Now, the clause that leads to the greatest financial impact and how to manage it early is that make good clause or the refurbishment clauses. So essentially, if you are the tenant, at the end of a lease, a tenant will generally be required to actually make good the premises. So it's important to know, what this actually involves so that we can actually plan for that accordingly. So, what is a make good clause? And I guess is probably a common question we have tenants or landlords ask if they've not, had much experience with commercial leases. So at the end of the lease, the lessee will have a general obligation to arrange the lease premises to be in a condition it was when the lease was entered into. So a make good clause enforces this general obligation, and it might require the lessee to undertake additional work so that the premises is at the lessor's satisfaction. So, the obligation then falls onto the tenant to adhere to that. So simply put, the make good clause is the clause in the lease that specifies to the tenant that the condition the premises must be left in once the lease is at an end and the tenant actually vacates those premises. So the make good clauses are different to what you might know as a redecoration clause, as the make good clause only relates to what needs to be undertaken at the end of the lease period, whereas your redecoration clause is quite common in retail shop leases. So often, the big shopping centres like a Westfields will require that, at the expiration of maybe the initial lease period. So you might have, as I mentioned at the start, a 5-year lease with 2 5-year options. So, essentially every 5 years, the tenant will be responsible for actually redecorating. They like in those big shopping centres for it to be seen as modern and not essentially looking too decrepit over that period of time. So that's very different to the make good clause and has very different obligations. So it's crucial that a tenant identifies whether a make good clause has been inserted into the lease, which, like I said, is very common. It's uncommon not to have one these days. And basically making themselves aware of that, yes, at the outset of the lease, but also revisiting that, obviously, knowing that they're coming up to the end of that term to understand what is actually due at the end of that lease term. So the tenant must give themselves adequate time to undertake the repairs before the actual lease end date. If it's not, then it may result in them having to pay extra amounts to ensure the work is done by the end of that lease date. So otherwise, the tenant will have to reimburse the lessor for failing to leave the premises in the condition that it was when they entered into that lease. So it is important to check, what the scope of works is required by the landlord, which should be dictated in the lease. So, the tenant needs to, understand, they're going to be required to remove, fit out and fixtures, or will some or all of it be come the landlord's property. So sometimes, the lease may stipulate that, yes, you've got to bring it back to the base shell unless the landlord agrees otherwise. So often the situation may come and may depend on who essentially is going to take over those premises. So if the premises is, for example, been set out as, and fitted out as a medical suite, a medical centre, and the landlord already knows that they've got an incoming medical practitioner coming into that to lease that space, it may be in their interest to leave that fit out there and agree with the tenant to leave it as is. But that will depend on what the landlord requires, and that will may require the tenant actually communicating with them prior to the lease end date. So the tenant otherwise will essentially need to reinstate the property to that original condition. So that's why it is important that we've also got a make good condition report, essentially. So when we take over the premises, we should have photos of what it was like as essentially as a base shell, or maybe you did take over a premises that already had a fit out, so that we can see exactly what was in place at that time to bring it back to that actual same state. So for example, the make good may include things like, replacing all the flooring, repainting walls, removing any extra data points or lighting or PowerPoints and things like that that were added to the premises since moving in. Or it will be, essentially a refresh. So it could just be limited to removal of their actual fixtures and fittings if it's agreed that the landlord wants to have the majority of the fit out remain. So what standard does the work need to be completed in? So generally the landlord satisfaction of a commercial or professional trade standard. So it can't just be the tenant who's, got no trade qualifications or anything, just going and, ripping out data points and things like that, and essentially not compliant with safety standards and things like that. So it does need to be undertaken by proper tradespeople in a quality workmanlike manner. So essentially, was the deterioration then as well of the general wear and tear, or has it actually been damaged? So, for example, if they do allow for the fit out to remain, maybe there was, carpet in the premises at the time you took over the premises, and the lease then should allow for fair wear and tear. However, if you've gone and put in, cabinetry and that's had to, rip holes in the carpet to do that, then that's not going to be considered fair wear and tear, and you may have to replace that damage that's been caused. Other things that often will have to be, removed as part of make good is things like signage. And in doing that, sometimes, we've got, things that are put on windows or big signage, that's needed holes drilled and stuff like that. As a result of the damage that's caused in removing those property items and goods, that all needs to be made good as well. So the make good clause, refurbishment clause, if you are a landlord then, so looking at the other point of view. So for the landlord, again, we still need to be checking what is the actual work that we're requiring the tenant to do. We need to be making sure as the landlord that the clause clearly outlines what standard the work needs to be redone to. So as I mentioned before, we want to make sure that it's done in a proper workmanlike manner and also to the landlord's satisfaction. As I mentioned before, landlord may want some of the fit out to retained, but we need to stipulate that and we need to have the control over that. We also need to ensure that we retain, if we are retaining any of the fit out, are we giving compensation then to the tenant for that? Or is the compensation simply that the tenant's not needing to pay the cost of these trades to actually go and remove these items? For repainting and reflooring, if they're obligations, we may need to nominate the actual approved finish. So for example, with painting, you might want to make stipulate that it's to the same colour that's currently on the walls at the outset of the lease, or that it's done in 2 coats of paint to a colour preference of the landlord's choice or something like that. Flooring, again, similar, similar colour or style or whatever that may be. We need to ensure that the tenant also is paying for these make good works as well. Obviously, for the landlord's perspective, it is a big cost and it's not something that we were responsible for putting in, and therefore we don't want to be responsible for the cost in making it good. So that's very important. Now, we also need to ensure as the landlord that the lease actually allows for them to cover the costs of the works if it's not done by the tenant or it has not been done to the required standard. So often, tenant comes to the end of a term, maybe that was, because of breach, because they've been unable to pay rent, and all of a sudden then, of course, they've not done the make good either. So we need to then be able to recover costs. So the way we could go about that is depending on what security mechanisms we have in the lease in terms of avoiding risk, but that could be relying and calling on upon the bank guarantee or a cash security bond that we have, or potentially if there's personal guarantees attached to that lease as well, enacting on them as well. The last thing we've got here is, does the actual lease outline when the tenant can commence vacating the premises? So, again, probably retail's a good example here. We want, retail shops to be basically trading essentially in that shopping centre until the lease comes to an end, which means make good works are a little harder to do. We might allow, as the shopping centre, they might be allowed, a week or 2 weeks for that make good, but we don't want them to be, shut for 2 months or whatever, to slowly carry out these make good works. Again, we don't want to be disturbing, other offices, other shops in the close vicinity. So it could be strictly stipulated as well that any works, such as the make good works, need to be carried out during after hours time as well. So the clause essentially that does lead to the greatest financial impact and how we can go about managing it early. So if there is no make good or refurbishment requirements in the lease, the tenant will be required to still return the premises in good repair. So it's very uncommon that's not in a lease, but often, we do see some weird and wonderful things where people have gone and drafted their own agreements, or they've used some document they've found online, or, lo and behold, the power of AI, they've quickly dictated something and think that's the great document, then they're going to use that, and it didn't have the make good clause. The landlord still does have the obligation, though, to require the premises be returned in good repair. Like I said, fair wear and tear is accepted, but that would mean, removing the detachable property. So requiring the tenant to remove any property that's removable from the premises that they've included in there. So, for example, things like desks and cabinets. Now, what happens then, I guess, if the tenants are not, going ahead and removing that property, because often, that happened to be the case as well, where they've just closed up shop and fled, and all of a sudden the landlord's stuck with, an office full of furniture. The lease will often stipulate then that if that's the case, the property can be considered abandoned, and the landlord can have the right to do with that property what they see fit, and then seek recourse against the tenant for the cost in doing that, engaging a reverse company, paying, dump fees, etc. The other thing is it will generally involve, as I said, removing all the property and completing the basic repairs. So the lessee must remove their property from the premises, and that includes signage, which I spoke briefly about before. And in doing so, they've got to fix any damage that has been caused during the lease period. We spoke about repainting walls, but also replacing any broken windows, which is a common one. So often, it could be a crack in a window that's happened over time. It's not been an issue to the tenant, but for the landlord that is, because they're wanting to make the property seem in very good condition to then release it potentially to a new tenant. And then making sure the property is actually in a clean condition. So again, the lease, we want to stipulate in there that cleaning is something they have to do, and that could be, full wash down of the external property, using proper chemical cleaning elements to do the inside and things like that. So there are a couple of things to be aware of. Essentially now I'm going to go through a bit of an example in practice and how we see the make good clauses actually operating. So in this situation, we've come up just random people. The first one is Cherry Blossom Designs. So we'll know them as CBD throughout this example. Now they've leased an office space from Supernova Rose, we'll know them as SR throughout this example, for a 5-year plus an option period of a further 5-year lease term. Now CBD did a full fit out on the premises, including custom reception area. They've put in new cabling, feature lighting, and branding throughout the whole space. Now, at the end of the first term, so the 5-year lease term, they no longer needed the office space, as most of their staff now work from home, and they didn't exercise their option essentially. So at the end of the term, CBD removed their furniture and the IT equipment and cleaned the premises. However, they didn't remove their fit out or any of the cabling they installed. They've gone ahead and they've repainted the walls themselves in a budget paint from some seconds tables at Bunnings, essentially. Now, CBD figured that the fit out could be useful for a new tenant, so they left the custom reception area cabling and feature lighting. Now, as I mentioned before, it could be, but that's at the landlord's discretion. That wasn't up to CBD to determine that, and they should have actually gone and sought that from SR. Now, SR said, no, we didn't want that fit out to remain, as it's essentially limited the capability of that commercial use for the space. The cabling and lighting, they're too personalised to CBD to use for the space for any other incoming tenant. The paint job was shoddy, and the colour choice wasn't approved by SR either. So SI's now, to rectify all these issues, they're gone ahead and hired a company to remove the fit out, cabling and lighting, and also hired a company to repaint the premises. So they've then gone ahead and claimed the full bank guarantee amount of the $80,000 and sent a notice claiming the remaining costs from CBD. So CBD claimed that SR wasn't entitled to this cost and they should have kept the fit out as it added value to the premises, and they claimed that the lease did not require SR to approve the paint colour, that it only needed to be a neutral colour, which they considered it was. Now, SR would be entitled to claim the rectification costs from CBD. If the bank guarantee or deposit did not cover the cost, then SR would also be entitled to seek this from CBD and the actual personal guarantors. Now, if CBD decided not to pay these costs, and the personal guarantee would be liable for this amount. So in this case, the personal guarantee is essentially generally the directors of the company, and essentially whatever the directors own. So if they've got, principal place of residence, investment properties, cars, cash in bank, that can all be called upon. So in some cases, the removal of the fit out, it can be very costly. And if there isn't sufficient cash available to pay the costs, then SR would have had the right to essentially apply to have that company wound up and then seek the remaining debt from those personal guarantees. So while SR would be entitled to claim the rectification cost in CBD, they would have the right to pay out the cost initially and then recover the costs at a later date. Obviously, from the landlord's point of view, they just need to make sure that that property is ready to basically be released as quick as possible, and then they can worry about the recourse and then going back and seeking that recourse about the outgoing tenant. So SR would also be losing rent while the rectification works are being completed, and that would be something that they could add into their claim as well, because essentially all make good works need to be done by the termination date. Otherwise, the landlord is entitled to essentially see that the lease is not terminated, maybe on a holding over period, and keep charging rent to that existing tenant. So how could this all have been avoided then? So this dispute could have been avoided if the lease clearly outlined what the works the tenant should have undertaken when undertaking the premises, which should have been something that was negotiated, drafted into the lease, signed off on both parties at the outset of the matter. CBD should have actually been checking with SR regarding the fit out before vacating. So it wasn't up to them, like I said, to take it into their own account and their discretion as to what they think should and shouldn't remain in there. And SR should have actually ensured that the lease expressly stated that they must approve the paint colour. So it's all well and good to say, hey, it should have been a neutral colour, and it's not. But if that's not included in the actual lease, that's not a requirement. So it is important to include these things. Now, holding over, I spoke a little bit briefly about before. And like I said, if the lease does terminate and all of a sudden the tenant needs another month to make good, that's when a holding over period could come into play. So when the lease term has actually expired, but the tenant remains in the premises without signing a new lease, this is what's known as the holding over period. So a lease will generally include a provision for this and what actually happens in this event. So it involves that the lessee becomes on a periodic lease. The rent amount will likely increase based on what it previously did. So for example, if it was previously increasing by CPI every lease anniversary date, that will be what it increases by, or potentially often a fixed increase. So, maybe a 4% increase on the anniversary date of the lease commencement date. That is again what the increased rent will be. It's not okay though for a landlord just to say, we're upping the rent by a random figure of, $20,000. That won't be acceptable. It will also involve, for holding over periods, the ongoing obligations to pay the outgoing, so the same as what they've always been paying under the lease. They'll still have the same repair and maintenance obligations remaining, and they've essentially got no rights to further renew the lease, even if the original lease had an option period, as the option period would have expired. So with the option period, generally, as a tenant, it's a very strict time frame that they have to comply with taking up the option period. So for example, most commonly, it's generally anywhere from like 9 months to 3 months. They have to give notice to the landlord that they wish to actually enact that option period. Because essentially, if they're not going to enact it within a certain period of time, the landlord needs that sufficient time to then go to market to try and find a new tenant to take over that lease at the expiration of the current one. So short notice period is required essentially to terminate a lease under a holding over period. And generally that's, your month by month basis. So generally you give 30 days notice and the lease will come to an end. Now, while on the face of it, this could have seemed like a good idea, for our landlord-tenant situation, to allow the tenant additional time to move out and actually complete those make good obligations by way of the holding over period, the landlord doesn't lose rent. So it is a win-win in that situation for the landlord. They're still getting rent while they're maybe still looking for another more permanent tenant to come in. However, from the landlord's point of view, there is no long-term security. So, yes, we can allow the tenant a month-by-month basis. That could continue on from, anywhere from 1 month to however, it's endless, 12 months, 15 months, whatever it is. It can make it harder as well for them to find a replacement tenant. If you've got a an existing fit out, the example I gave before, a medical center, and all of a sudden you're wanting another business completely different to come in, a mechanic or something like that. It's very hard for, potential tenants to come in and really envisage what they're going to do with a place that looks completely different to how their business is going to operate. Sometimes having it brought back with make good to that base shell, they can kind of have a blank canvas to see what they're going to do with the space. And also time, if the full fit out's there, they know that it's not going to be available for them to rent, straight away. It's going to take, maybe a month, 2 months to make good. It can make it harder to find the replaceable tenant in those regards. So the other thing as well is that the allowed increase may not reflect the market value. So generally a market increase can take place if an option period is taken up. Now, if the tenant is refusing, for whatever reason, doesn't want to take up the market, the option period, which would include a market value reassessment of the rent, they're only going to increase by, CPI or fixed increase, which could be a very small increase compared to what potentially the market's grown at over, if it was a 5-year lease, a 5-year period. Now, for a tenant though, in terms of them, there is also same as landlord, no long-term security. So either party can give that 30 days notice or whatever stipulated lease. It's most commonly 30 days, 1 month's notice. So, for a tenant, it's not easy to find lease premises and negotiate them, get everything in order in terms of bank guarantees and insurance and stuff. So if you've only got 1 month to do all that, it's really cutting it fine and could be a high risk for, all your staff, your clients, your business to be kicked out and have somewhere to go within 1 month. There could also be, higher rent costs. Obviously, we're not doing a market rent increase, but there will still be the CPI and fixed increase, or fixed increase, whichever one is taken up on as per the lease. And also they will lose the right to actually renew. So as I said, if they don't take up that option period in that strict time frame, they can't then do that during the holding over period, because that would have expired by that point in time. So example for this one is using the same tenant and landlord as we had in the previous example. So, but in this case, the lease has expired and the tenant decided just basically they weren't going to do any of the work at all within the time frame, and if they were going to exercise the option or not, they weren't sure. So initially, SR was happy for the tenant to stay on a periodic lease. But after 3 months and no new lease being signed, SR did find a new tenant that was ready to move in at a higher rent amount. So SR issued CBD the notice to leave, giving that 1 month's notice. Now, the problem was for CBD, as they had assumed that they would be able to remain in the premises and therefore, had not undertaken any make good planning or, looking for future premises. So consequences for them was essentially that the holding over period with CBD, they had to pay obviously the higher cost in rent. They then had to obviously rush to find a new premises within 30 days. Like I said, that's quite hard and difficult to do so, and also obviously negotiate a new lease and get everything in play. CBD hadn't given themselves enough time to meet their make good obligations, and they were required to, as a result of that, basically pay SR the cost to attend to this on their behalf. On the other hand, for SR, if they had assumed that they would be able to come to an agreement with CBD only to have CBD, give this short notice to vacate, SR would be left trying to find a tenant in a very short period of time, and potentially they would have been losing, months of rent while they look to find a new tenant if the roles are reversed and the tenant had just given that 1 month's notice. And the landlord wasn't expecting it, they would be at a loss with rent. So while the obligations do not necessarily end when a tenant vacates, if a tenant does vacate the premises before the expiry of the lease, they will still be bound by the lease until a new tenant has been found. So generally with most leases, they will include like a sublease clause or an assignment clause or transfer of lease. So often, like I said, you can't just say, no, business plans have changed, we no longer want the premises, we're not leasing them anymore, and you're in a 5-year lease term and you've only taken up 2 years of that lease term so far, you're still bound for that remaining 3-year period. And it's up to the tenant then to go ahead and find an alternative tenant to basically take over the premises. There's nothing stopping that tenant from engaging an agent to assist with that process, but the responsibility falls on the tenant to keep paying the rent costs until that new tenant can be found. So, like I said, there is often, the full assignment of the lease, but there's also a sublease clause generally in most leases to allow the tenant to at least sublease, a portion of those premises if they can't find someone to assign the whole area to. And they could maybe, look to split the premises into 2 subleases, or maybe the tenant's quite happy to operate, a smaller operation in half and sublease the other half out if it's just been a decline in the business or something like that. Now, if they did want to go ahead and do the full assignment of lease, but the assignment did not release the tenant or personal guarantee, that's going to be an issue. So we need to make sure from a tenant's point of view, if there is going to be an assignment or lease, that we're released from all liability going forward. So, and that means then from the incoming tenant that's being assigned the lease, they're then therefore taking on that risk. And for the landlord to be satisfied with that incoming tenant, they need to make sure that they've got the same, if not better, security in place, which could be things like the personal guarantees, a security bond, which could be 3-6 months rent in cash, and generally at least a month's worth of rent payable in advance. Now the tenant didn't comply with their make good obligations in this situation, which is an issue. And also the final adjustments for outgoing couldn't actually be calculated until after the tenant vacated the premises. Now, from the landlord's perspective, they're obviously going to withhold on any security they've got until those things have been done to ensure that they're not at a loss should they not occur. Now, continuing with the example, so CBD and SR in this case, so CBD had only been in the premises for 3 years before realising that they needed to downsize. So they found a company known as Desert Poppies to take over this lease. They, downsizing, they didn't want to just sublease. They thought it's easier just to assign it to Desert Poppies to take over completely. Now, SR consented to the assignment of the lease as the head landlord, or the landlord in this case, and all parties signed the deed of assignment, and DP then provided a new bank guarantee, but the deed of assignment expiry stated that the signor remains liable for the performance of the tenant's obligations under the lease despite the assignment. Now, that's kind of what I mentioned before in terms of the risk. From a tenant's perspective, they want to de-risk themselves. They don't want to have a clause like this included that keeps them tied to this lease and keeps them tied to ensuring that the person that they're assigning the lease to, in this case Desert Poppies, is performing, because it's it's beyond control of the tenant, and they essentially want out. So we do need to make sure, with assignment of leases, and the deeds that go along with that, they're being drafted correctly by lawyers. And if we're signing them, yes, it's been drafted, but it's been drafted for the person who instructed that lawyer to draft it. So if we are the incoming tenant or the outgoing tenant, and we haven't instructed the lawyer to draft it, we need to be checking that document to make sure that it meets our requirements, and we are the risk is not too high for us. So within 8 months then of DP having taken over this lease, they essentially stopped paying rent. They ultimately entered into receivership. Now for SR, thankfully for them as landlord, they claimed that unpaid rent on the bank guarantee, and they advertised immediately for someone else to take over the lease. However, that took a further 6 months before a new tenant was actually found, which sometimes with commercial leases, it's not as simple as renting a residential place. The vacancy rents, can be much higher and much longer periods. So that's quite common for something to sit on the market for that period of time, which meant because of that clause we had drafted into the assignment deed, the outgoing tenant was still responsible for that cost. Now, SR, they knew this, and they then went ahead and made the claim on CBD and the personal guarantees that were attached to that as well, for both the outstanding rent, all of the outgoings, the make good costs, and even the legal costs. So it is very important to make sure, from the landlord, they done everything right. They made sure that assignment deed was in their favour. Would they have negotiated and agreed to something of less terms and put them a bit more risk? Potentially, but they didn't have to worry about that, because CPD, probably didn't get lawyers involved, probably didn't even, understand the clause that they were signing off on to agree to all this. So Instead of assigning the lease, CBD could have also asked for an actual surrender of the lease. So often, as an incoming tenant, sometimes there's only, if you've got I know in this case it was 3 years, but sometimes a 5-year lease, you might only have 1 year left on it. As a new business or even an existing business, you don't really want to take over a lease and go ahead and, do these extensive, $500,000 fit out to be guaranteed 1 year. Like, that doesn't really make much sense. So often there'll be a deed of surrender that's done for the existing lease, and we are entering into a fresh new lease with our terms, with our conditions, which means we could be getting incentives as a tenant, and we've got what we want then for a much longer period of time. Now, how could this have all been avoided? So when the deed of assignment was signed, CBD and their director could have required that they be released from the lease. If they had a proper advisor that was legally trained, they likely would have told them this, and it would have been negotiated. That could have been, the landlord might have agreed to it, but they might have said to, the dessert place that was taking over DP, hey, you need to then increase your cash bond that you're putting or bank guarantee, and we want the personal guarantees, and they would have done their due diligence as well on those personal guarantees to make sure they actually had assets they could call upon if things soured like they did in this situation. Instead of assigning the lease as well, CBD could have, as I mentioned, asked for the surrender of lease and entered into that new lease with DP. So in summary, the greatest financial exposure for tenants typically arises at lease exit, not actually during the term. So yes, we've done, I get the fit out is an extensive cost, but that's something, most businesses plan for. They've forecasted, they've got quotes and stuff before they even entered into the lease. So they're well aware of that. What most tenants don't do though is say, hey, now what's it going to cost me to make good these premises? And sometimes the lease is coming to an end or they're not renewing because they're retiring or whatever it is. So they actually don't, they haven't factored this in, but it is really important. Also, the break clauses are strictly enforced. So any non-compliance can invalidate early exit rights. The other thing to summarize as well is make good and the yield up obligations can result in significant unexpected costs. So we need to be aware of that. The final risks as well include outgoing adjustments, the bank guarantee drawdowns, and also compliant upgrades. So as mentioned, those outgoing adjustments, like I said, we don't get that audited statement until after the financial year. So that's why often with the bank guarantee, there's an expiry date, and we do not want the expiry date to be the expiry date of the lease. That is why it's often for a period of time after that. So it might be 1 year after the lease end date, and that's to allow for things such as this, the outgoings adjustment. If that lease expired, for example, just after the financial year in August, and we've only paid August outgoings, which for whatever example then ended up significantly increasing, if that lease bank guarantee expired, we wouldn't then have recourse for that. So that's why that's really important. Now, holding over after the expiry date of the lease can trigger penalty rent and also the loss of security. And the other thing to note in summary is early planning and legal advice is critical to minimize the costs and also avoid disputes. Often the leases will have, dispute resolution clauses, what will happen if a dispute arises. But it is important to get advice early in the piece rather than once it's too late. If we are planning to not take up option periods, we know we're going to exit, we've already got, new premises planned, we need to start liaising, with the landlord to let them know, we're moving essentially, we're not taking up the option period. What are your make good requirements? Can we leave all of this fit out here, or are we going to be up for $500 in make good cost to get rid of it all? The other thing to note as well is if the lease period is longer than 3 years, the lessee still has a requirement to keep the premises in a clean condition regardless of whether there is a make good clause in their lease, and that actually falls under the Property Law Act. So it's actually legislated regardless of whether you had a lease in place or not. And that obligation on the lessee to yield up the premises in good and tenable repair also falls under that legislation. So obviously, a few things to note and hopefully you've been able to take away from. And obviously, we're here to help if you do have any questions. I'll be happy to answer those now. So I'll give you a minute if you wanted to pop anything in the chat bar. Otherwise, feel free to take yourselves off mute and I'll go through them with you. Thank you. Oh, I just had one pop up I thought I had. Give me a sec. No, sorry. Let's give another few seconds if there's anything. Otherwise, I'll put my contact details up there. What we'll do as well post this webinar is if you do have any questions that you don't want to ask in front of everyone or you don't want to post in the main chat, we will be reaching out to each of you individually. Feel free to lock in a time with me to go through whatever it is, anything to do with commercial leasing. Otherwise, happy to talk about property matters or commercial estate planning matters in general. Our contact details are up there, but like I said, we'll reach out to you directly. You'll also get a copy of these slides and a recording of this presentation as well. So if I have gone through things a little bit too quickly or there's something you wanted to kind of rejog your memory on, then you'll have them as well. As I've mentioned, disputes over tenants' obligations at the end of a lease, they're quite common, and they're usually the result of grey areas in the lease agreement about what the make good provisions are and the costs associated with exiting the lease. So, our main game as lawyers here at NB Property Law is to ensure that we're giving the proper advice. And, if we are drafting those leases for landlords or reviewing the lease for a tenant, making sure that there is no ambiguity in the lease when it comes to the make good clauses and the exit terms of a lease, whether it be commercial, retail or industrial, and ensuring that your interests are actually protected and that you know what they are and what your obligations are. So happy to help, owners of businesses or tenants, whatever you're looking to do in terms of your leasing requirements. Feel free to contact us there. But otherwise, thank you very much for your time, and hopefully you were able to grab some insightful information.